Man died intestate. That is, without making a will. He is survived by his wife, a son and his nephew. He has left behind a house, bank account, life insurance policies, mutual funds, and shares. He has nominated his wife for his savings bank account, insurance policies, and mutual funds. His nephew has been nominated in the shares. This brings us to the question: who is a legal heir and who is a nominee? Is a legal heir same as a nominee? Would a nominee of a bank account and shares be entitled to receive the money on the death of the holder? Let's find out more through this video. A legal heir is determined by law to succeed to the assets of the deceased person. Some or all of the legal heirs may be beneficiaries or legatees under a will. A will relates to the assets that you own, which may clearly define such legal heirs entitled to a share or shares of the assets. It is often a misconception that anyone who is a nominee to any movable asset, say bank account or shares, becomes the legal owner of such asset. But this is not true. According to law, a nominee is only a trustee or custodian of such assets for or on behalf of all legal heirs. Which means, when the holder of the bank account or insurance policy dies, the person nominated is entitled to demand the payment of amounts due from the bank or insurance company and hold it in trust for the legal heirs. This discharges the paying bank, but it does not determine the rights of the heirs in terms. So, if a person dies without making a will and also has not nominated anyone, the legal heirs will end up going through cumbersome process to get the claims or proceeds. If a valid nomination exists, the concerned institution is bound in law to transfer the money or movable assets to the nominee immediately. Succession to immovable property like house, flat, plot of land is governed by the will or by virtue of the intestate law of succession if a will is not made. There is no concept of nomination in immovable properties, except in housing cooperative societies, where a nominee may be appointed. Even here, the nominee is usually only a trustee or custodian and not the legal heir. While opening a new account in a bank or post office, you will find a column for nomination in the application form. You may nominate a person at the time of opening the account, or, if you have missed assigning a nominee, you may do so even at a later date by requesting the bank or post office by filling the prescribed nomination forms. According to Section 45Z subsection 2 of the Banking Regulation Act, 1949, on the death of the depositor or if there is more than one depositor, on the death of all depositors, the nominee is entitled to receive the proceeds lying in various accounts. And again remember, the nominee does not become the owner of any of these amounts but holds them in trust. A public provident fund is a tax-free, government-backed savings scheme, wherein interest on the account is set for every quarter and is paid by the government. You can nominate one or two persons to your PPF account. Amount up to Rs 1 lakh can be claimed by legal heirs even without producing succession certificate or an Administrator General's certificate, wherever permitted. So, if there is no nominee to a PPF account, the balance will be paid to the legal heirs on obtaining a probate or succession certificate from a competent court. A policyholder can appoint nominees and also specify their shares in the policy proceeds. If the nominee is not incorporated in the text of the insurance policy, it can be made by an endorsement on the policy communicated to the insurer and registered by him in the records relating to the policy. Section 39 of the Insurance Act, 1938 provides that insurance company must hand over the amount to the nominee mentioned in the policy. The new rules to the insurance law in 2015, the concept of beneficial nominee is introduced. This means that only immediate family members such as spouse, parents and children should be nominated, so that the insurance money is paid to the nominee. This is applicable to all insurance policies that have a maturity date after March 2015. If you want to nominate a person other than the family member, you have to prove to the insurance company that there is an insurable interest for the person. A mutual fund is nothing but a common pool of money collected from people, which is used by an experienced fund manager, who invests in the securities market. Nominee in mutual fund is a simple procedure. You could fill in the nomination details either at the time of investment or nominate at a later stage by completing the requisite documentation. This is applicable to both physical and online investments. And, if there is a joint holder to the mutual fund, the ownership will remain with the joint holder until the last surviving joint holder is alive, and then pass on to the nominee. As you have known, holding and trading of securities happens through electronic form, or they may account through depository participants. The demat account holder may, at any time, appoint a nominee to his or her account. Nomination for shares is governed under Section 72 of the Companies Act, 2013 and Companies, Share Capital and Debentures, Rules, 2014. Such a nominee is merely a custodian of the shares till such time the legal heirs establish their succession. Death of the account holder, the nominee should contact the depository participants for further instructions on the account. Where a nominee is not appointed for the demat account, the process of transmission of shares from such account is provided under SEBI Listing Obligations and Disclosure Requirements 6th Amendment Regulations, 2018. So, don't you think you should make a will? Thanks for watching. And if you find it informative, please don't forget to like, share and subscribe.